Hello guys, this is Tshepo Masilela of Tshepo Masilela Attorneys. Our topic for today is customary marriages. We are just going to run through the most commonly asked questions about customary marriages, and here it goes. Customary marriage is a marriage that has been concluded in terms of customary law. That means the marriage must have been concluded in terms of traditional laws and rituals. So, in other words, the marriage is concluded in the African traditional way as opposed to the Western civil way of concluding marriages. So with a customary marriage, you don't get a marriage certificate like you would if you concluded a civil marriage at the Department of Home Affairs. With a customary marriage, you simply negotiate and conclude the marriage in terms of custom. A customary marriage may be registered or must be registered at the Department of Home Affairs. However, even if it's not registered at the Department of Home Affairs, it is still considered a valid customary marriage if it has been negotiated and celebrated in terms of customary laws and traditions. So there are two primary things that are required for a customary marriage to be considered valid. Firstly, it must be negotiated in terms of custom. So the families of the two parties must have come together as per the African traditional laws to negotiate the conclusion of the marriage. So the families must have met to thresh out how the marriage is going to be concluded. For example, how much Lobola will be paid and how the bride will be received, whether gifts will be exchanged, what the gifts should be. All of those things must have been negotiated as per the traditions and customs of the parties being married. So that's the first thing. The second thing is that the marriage must be celebrated in terms of custom. So there must be some kind of celebration in line with the traditions and customs of the parties being married. You know, if part of the celebration is the exchanging of gifts, in some customs, certain parts, a cow must be slaughtered and certain parts of the cow must be given to certain significant members of the family. You know, the customs may differ from one tribe to another, but the marriage must be celebrated in terms of the well-known traditions of the parties being married. So those are the two main aspects of a customary marriage that must be present in order for a customary marriage to be considered as valid. It must be negotiated in terms of custom and it must be celebrated in terms of custom. No, you may not enter into a customary marriage if you are already in a valid civil marriage. So if you are already married in terms of a civil marriage and there's a marriage certificate, etc., if you enter into a subsequent customary marriage, that customary marriage will be invalid, meaning there will be no rights and obligations arising from that customary marriage. So the parties to the customary marriage will not have rights and obligations arising from that marriage because that marriage will be invalid simply because you are already in a civil marriage. Yes, in terms of the Recognition of Customary Marriages Act, it is a requirement that all customary marriages must be registered at the Department of Home Affairs. However, even if the parties to a customary marriage fail to register the marriage at the Department of Home Affairs, that marriage is still valid and binding. So you may not at a later stage claim that the customary marriage is not valid because you never registered it at Home Affairs. Although it's a requirement that it should be registered within 3 months, the failure to register a customary marriage does not render that marriage invalid. Yes, in South African law, customary marriages carry the same rights and obligations as any civil marriage. So they are of the same status before the law as a civil marriage. So parties in a customary marriage are considered to be married in community of property unless they had concluded an antenuptial contract prior to entering into the marriage. So a customary marriage, just like any civil marriage, can be terminated either by death or divorce. So in the event of a divorce, the parties must still institute divorce proceedings in a court of law, and a court will issue a decree of divorce to signal the termination of that customary marriage. So you may not simply just walk out of a customary marriage. You will still be considered legally married unless you approach court for divorce. Yes, if no antenuptial contract is concluded between the parties prior to the conclusion of a customary marriage, then that customary marriage will be in community of property. Lobola is not a prerequisite for a customary marriage to be valid. So even though commonly when a marriage is negotiated in terms of custom, Lobola will be one of the primary things that are negotiated and agreed. It is not a prerequisite that Lobola must have been paid or paid in full before a customary marriage will be considered to be valid. For example, sometimes the families will negotiate and agree that the initial payment will be X amount and the balance will be paid at a later date. However, the families will still proceed to celebrate the marriage in terms of custom, and the bride will be handed over to the groom's family in terms of custom. That marriage will still be considered to be a valid customary marriage, even though Lobola was only partially paid. Sometimes the families might agree to a certain Lobola price, but the groom may not be in a position to pay it at that time, and the families may agree to proceed with the celebrations and the handing over. So each customary marriage will be assessed on a case-by-case basis, but Lobola payment is not a prerequisite for a customary marriage to be considered valid. Yo, my lipstick is finished.